before lunch or right after lunch, Your Honor.
All right. So when you intend to call that witness, just ask for a break.
Yes, sir.
All right.
The other thing is, I didn't object during jury selection to references to this murder, but I would appreciate that the state not use words that invade the jury's province and imply that the ultimate facts have already been decided, like kidnapping and murder, things like that.
Mr. Levine?
Your Honor, I will be using the words murder and kidnapping. There's nothing wrong about that or objectionable. That's what he's charged with. There's nothing inappropriate about saying those words. Obviously, the jury is here to determine whether he's guilty of those things.
Ms. Thornhill, are you referring, for instance, if Mr. Levine is asking a witness, at the time of the killing or murder, as Mr. Levine wants to say, that it's that type of,
Right.
when he's talking to a witness, not saying things like that.
Not talking about the charges, because of course those are what the charges are, but speaking with, say, a detective and saying, when Collin murdered his mom, when killing is fine, that's fine, homicide is fine, incident is fine, describing facts is fine, but using the words that are going to be, it's going to be the jury's duty to determine whether a kidnapping and a murder happened.
Additional response, Mr. Levine?
Your Honor, first I thought she was referring to opening statement, which doesn't sound like she has a problem, and she should not have a problem with me saying murder or kidnapping opening statement. As it pertains to questioning of the witnesses, if I feel that it's appropriate and there's nothing to the contrary from the court, I don't think there would be anything inappropriate about using those words.
Yesterday he called for
openings.
knife.
You're not talking about openings.
I mean, I would prefer that we keep it more neutral at this point, rather than assigning actions a certain legal description or conclusion that the jury is going to be required to reach, rather than either one of us.
I think that the use of the word murder or kidnapping or anything that connotes a legal conclusion about this killing or these events, depending on how that comes out, the context in which those words are used, I think certainly sometimes that would be a sustainable objection. For instance, if you're asking a witness questions and you say something like, at the time that the defendant murdered his mother, did you know X, Y, or Z, or something like that. I think that is inappropriate and argumentative. I'm a little uncomfortable saying you can't say any of that in opening statements until I hear that. So just be on your toes, Ms. Thornhill, and I'll entertain any objection you have at that time. Of course, openings are not supposed to be argument, so the state needs to be cautious about its word choice in opening statement. But I could envision a circumstance when use of the word murder or kidnapping would be appropriate in opening statement and not argumentative. I think it just depends on how it comes out.
I understand.
So I'll direct the state to avoid using those words in an argumentative context during the course of the trial until closing arguments, especially when questioning witnesses. Do you have any questions about that? All right.
And I will say that this arose yesterday because Mr. Levine referred to the knife that was going to be produced in evidence as the murder weapon. So it's that sort of context that concerns me.
Anything additional, Ms. Thornhill?
Just about unsupported opinions being offered by witnesses, things like bragging, unremorseful. We touched on that briefly the other day, just as a reminder, so that I'm trying to avoid me standing up objecting over and over and over.
Again, I think a lot of those things are context specific,
I
and
agree.
some lay witnesses can give opinions based on everyday observations. For instance, if someone is crying, I think it's appropriate for the witness to render an opinion that they looked sad. But in general, I agree with you that lay opinion, when not supported by common sense deductions, is not appropriate. But you'll just have to cross those bridges when and if we come to them.
I like to say we can jump off that bridge when we get to them, but maybe that's just me being pessimistic.
Anything else?
No, sir.
Mr. Lemay, nothing?
No, sir.
All right. Do we know if the remaining juror has arrived?
Yes, they're already sending him up.
They're on their way
They're
out.
sending him up.
All right.
Does that mean I have time to take a quick break?
Yes. Counsel and Mr. Hendry, if you tell Ms. Thornhill this when she comes back in, sometimes lawyers in their opening statements or closing arguments, more often closing arguments, will hearken back to something that someone said in jury selection. If that is in anyone's intention in this case, please do not identify a juror by name. Just one of you or something like that, or if you must identify the person, which I don't know why that would be necessary, use a juror number.
Yes, Your Honor, I'll let Ms. Thornhill know.
All right. Ms. Thornhill, the state proposed jury instructions, did you receive those?
I did, and I reviewed them.
The preliminary instruction and the note-taking instruction appear to be standard. Is there any objection to them? And again, you do want me to include the portion regarding your client's right to remain silent?
Yes, please.
All right, we're ready when you're ready.
if you recall during the motion to eliminate hearing that during the 911 call, Collin asked to be taken to the back so he was not in here while listening. He would prefer that again. I don't know if that's logistically possible.
It is. It's his right to waive, to be present. Does the state have any objection to that?
No, Your Honor.
I need to inquire of your client.
Right.
Is that being played today?
I don't know.
Yes, Your Honor.
All right. Mr. Griffith, would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You heard what your lawyer just said.
Yes, Your Honor.
I recall that during the hearing regarding the 911 call that was placed in this case, that you asked to be excused from the courtroom. And is that your desire when it's played during the trial?
Yes, Your Honor.
You understand you have the absolute right to be present for the entirety of these proceedings, including the presentation and publication of evidence before the jury. You understand that?
Yes, Your Honor.
Have you had an opportunity at some point in the past to listen to that recording?
No, Your Honor, but I don't have a desire to.
You understand you have the right to examine all of the evidence that's being presented against you.
Yes, Your Honor.
And you do not wish to do that. And you do not wish to be present when it's published if it's received in evidence during the trial.
Yes.
Have you discussed this with your lawyers thoroughly?
Not thoroughly, but I don't think we have any objection. If you have an objection to it, I will set the return.
Judge, we have not discussed it, for hours or anything, but we have discussed it multiple times, and Collin has been consistent in his wish to not be present while it is played. I feel confident that he's making an informed decision.
If you have some questions for your lawyer or some additional concerns about whether or not you should be present when it's published, I'll give you that time right now.
Do you want to go in the back and talk real quick?
All right. Did you let Mr. Hertel know just to hold them in the hallway for just a moment?
Or if it's probably not going to be played before the break, the
All right.
morning break.
That's a
let's do
good
that.
idea.
Yeah.
Don't hold them. We'll handle it after the break. But we do need to talk about at that time where he's going to go,
Right.
because
I will speak with,
I don't know if you want the jury to see him going back through the holding cell doors, but
yeah, and I don't know that I mind that or not. We'll have to talk about that a little bit more.
all right, we're good, Mr. Hertel.
All rise, please.
Please be seated. Good morning. Welcome back. Again, my humblest thanks for your continued service in this case. You have been selected and sworn to try the case of the state of Florida versus Collin Griffith. This is a criminal case. Collin Griffith, the defendant, has been accused of the crimes of first-degree murder and kidnapping. The definition of these crimes will be explained to you later. I want to remind you, you must decide this case based on the evidence presented and the law that I give to you. Evidence consists of the sworn testimony of witnesses, exhibits admitted into evidence, and anything else that I tell you to consider as evidence. The state's charging document, the indictment that I read to you during jury selection, I want to remind you, is not evidence and you are not to consider it as any proof of guilt. Remember that it is my responsibility to decide which laws apply to this case and to explain those laws to you. It is your solemn responsibility to determine if the state has proved its accusations against the defendant beyond a reasonable doubt in accord with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Now, before we go any further, it might be helpful if you understand just a little bit about how a trial is conducted. At the beginning, the attorneys will have the opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. However, what the attorneys say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined or questioned and cross-examined. Documents and other exhibits may also be produced as evidence. Following the presentation of evidence, the attorneys will have the opportunity, again if they wish, to make a closing argument, and following those arguments, I will instruct you upon the law applicable to this case, and you will then retire to consider your verdict. You must not form any definite or fixed opinions about the merits of this case until you have heard all of the evidence, the arguments of the lawyers, and the instructions on the law. Until that time, remember, you must not discuss this case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. Jurors must decide the case without distraction and only on the evidence presented in the courtroom. Jurors must not conduct any investigation on their own. That includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to the case or the people and places involved with it. You must not visit any of the places mentioned during the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Remember, if you were to investigate, research, or make inquiry on your own outside the courtroom, I have no way to ensure that what you are doing is proper and relevant to the case. The parties likewise do not have the opportunity to dispute the accuracy of anything that you may find, to provide rebuttal evidence to it, or to make argument with respect to that evidence. Non-court inquiries, investigations, and communications unfairly and unlawfully deny the rights our judicial system promises. Now, remember as well, this prohibition regarding communication would include communication with anyone, whether that's close family, friends, employers, neighbors, and each other. No communication means no in-person communication, telephonic, electronic, such as emailing, text messaging, or posting information on an internet website or social media application, or any other form of communication. As I've mentioned during the trial, we will be taking recesses, and you are permitted to go about your personal affairs during those times. However, it is important to remember that the prohibition on communications applies to the case during these recesses. That's whether you're in the courthouse or anywhere else. If at any time you find yourself in a situation where others are discussing the case in your presence, leave that situation immediately, and at the first opportunity, report it to me by writing it down, giving it to a bailiff, and otherwise keeping it to yourself. As I mentioned, all cell phones, computers, tablets, and other devices must be turned completely off when you are in the courtroom. You may use these devices during the recesses, but even then, remember, you may not use them to gather any information related to the case or to communicate with anyone. Do not take photographs, video recordings, or audio recordings of the proceedings or of each other. Each of you has a right to privacy. We don't want that jeopardized by someone taking pictures or making recordings. I want to remind you that a violation of these rules related to communications and outside investigation, violations, I should say, come with serious consequences, including contempt of court, which is punishable by jail and fines. Also, remember, a violation would very likely result in a mistrial, meaning I would send everybody on their way and we'd start all over from square one. That's an expensive proposition for the court, the lawyers, litigants, witnesses, court personnel, your fellow jurors, and the community of taxpayers who foot a major portion of this very public expense. Now, the attorneys are all trained in the rules of evidence and trial procedure. It is their obligation to make all objections that they feel are proper. Now, when an objection is made, you must not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. With respect to objections and other legal matters that will arise during the trial, it will be necessary from time to time that I confer with the attorneys outside your hearing. I attempt to minimize the inconvenience to you and having to get up and go back to the jury room by conducting as many conferences as possible out in the hallway with the court reporter, the attorneys, and the defendant, who will have a headset here in the courtroom, and one of his lawyers with him will be out there discussing those matters outside your hearing. You might have heard such conferences referred to as sidebars. Many conferences can be handled in that fashion. However, I assure you there will be times where the arguments I need to consider are more extensive and not properly received here, or in the hallway, I should say, with you waiting here in the courtroom. So you will be asked to step into the jury room from time to time. No matter where that conference is held, you must not speculate on what we are discussing during any of those times. If you would like to take notes during the trial, you may do so, but you are not obligated to take notes. That's up to you. If you decide to take notes, don't get so involved in that process that you become distracted from what is occurring in the courtroom. Among the many things I will be telling you about how to weigh and consider the evidence, one thing I will tell you is that you should consider not only what the witnesses say, but how they act. You can imagine if you're looking down most of the time taking notes, you might miss some important nonverbal information coming from the witness stand. Also, do not be influenced in any way by the fact that I will be taking notes throughout the trial. I do not do that because I think this, that, or the other thing is critical to your determination. I do it simply to save us time later in the case in the event there is a dispute as to what occurred earlier. If I did not have detailed notes, I would have to ask the court reporter to hunt through her stenographic record, find what I'm looking for, and read it back to me outside your presence. She is eminently capable of doing that, but it is quite taxing for her and time-consuming for all of us. So that's the only reason you'll see me taking notes. If you do take notes, whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of any other juror. Notes are not entitled to any greater weight than each juror's individual memory of the evidence. Mr. Levine, does the state wish to give an opening statement?
Yes, thank you.
You may proceed.
All right, good morning, ladies and gentlemen. It was a Sunday evening, September 8th of last year, in Auburndale, Florida. And it was at that time that the defendant viciously and savagely unleashed his full fury and hatred towards his mother upon her, when he stabbed her with such force that the knife went shooting through her neck muscles, through her esophagus, through her trachea, through her thyroid cartilage, and shot out the other side of her neck. You will hear and see that as this happened, she began to bleed, and bleed profusely through the huge gash in her neck. While she bled, the defendant was there and watched as the blood came out of the huge hole in her neck. You're going to hear that he was there as he watched the blood and the life drain from her body until she took her final breath and was officially dead. You're also going to hear that this was exactly what the defendant meant to do, and that this is exactly what the defendant had thought about doing and had wanted to do for quite some time. So much so that he told multiple people, including multiple Charlotte County Sheriff's Office deputies and his own grandfather, the father of the defendant's mother, Kathy Griffith. His name's Robert Willantis. You're going to hear from him. He'll fly in from New Mexico, and he'll tell you about those haunting statements that the defendant made. And you're going to see that exactly what the defendant said he wanted to do and said that he would do, he accomplished on the night of September 8th of last year. But how did Kathy Griffith get there, bleeding out on her mother's kitchen floor? In order to understand that, we're going to have to take a step back and take a walk through some time. So you're going to see, of course, not just what happened on and around September 7th and September 8th, some of the critical time leading up to the murder, but you're also going to see and hear how this all began. Now, we're going to take a trip back to February 14th of 2023, the year prior to the defendant killing his mom. At that time, the defendant lived in Oklahoma. And you're going to hear on February 14th of 2023, the defendant killed somebody else when he shot that person 2 times. He shot that person in the chest, and he shot that person in the head. You're going to hear that it was undisputed that he shot that person, that he was arrested for that killing, and that he has not been charged to this date. Now, after that killing, ladies and gentlemen, the defendant, as a little bit of time progressed, he moved back to Florida. He had been living with his dad for a number of years in Oklahoma, approximately 3 years or so. While he was living in Oklahoma with his dad, his mom lived in Florida in some different places, but including Port Charlotte most recently. And you're going to hear that while the defendant lived with his dad, the mom, as any mom would, greatly missed her son. And she didn't get an opportunity for different reasons, including a very controlling dad that the defendant was living with. So Kathy Griffith basically didn't have much contact with her son, not because she didn't want to, but she would try to call him and talk to him, and it pained her greatly that her son was not with her. You're going to hear that there's another brother, an older brother. He really doesn't have much to do with this case, but nonetheless, there was an older brother who lived with his mom, Kathy, for a period of time before he moved out of the house when he was old enough. So, as the defendant moves to Florida, his mom wanted to make up for lost time. That was 3 years, 3 critical years of her life and his life when they didn't do mother-son things. They didn't spend time together. They didn't have all those opportunities that maybe other kids and other parents had. So Kathy, the defendant's mom, tried to make up for lost time. And she took her son on multiple vacations. They took cruises. They went to Disney World. They traveled out of the country. They went to Washington, D.C. And she spent all her time and affection and money on the defendant. That was her son. And that's who she had missed for all those years. Now, was Kathy Griffith the perfect parent? No. Was she the perfect person? No. But nobody is. But you're going to hear that she gave everything that she had, including her life, to try to take care of the defendant and spend as much time as she could with him, even at the cost of her life, which ultimately is what happened. Now, as the defendant and his mom lived in Charlotte County, in Port Charlotte, they lived in a house, a well-kept house. It was the two of them. And they did plenty of things together. Like I said, they went on vacations. They went to the movies. They hung out. It was just the two of them. So they had nothing but basically one-on-one time. And you're going to hear that Kathy Griffith, like any mom, expected certain things. These weren't off-the-wall, dictator-like things. These were simple things that she thought would be appropriate to teach her son about responsibility and respect. Chores, minimal chores, such as weed whack in the backyard, taking trash and food or candy out of his room, helping her around the house with whatever little odd jobs might happen. But you're going to see in here, the defendant wanted nothing of that. He didn't want to be inconvenienced. He didn't respect his mom. He didn't care about his mom. And wherever this deep-seated anger and hatred came from, it was real within him. And he told people about it. So as the days turned into weeks and weeks turned into months, his anger, as you'll see, was building and building.
Judge, I'm going to object to this being argumentative.
As the time went on, you'll see that the mom had to deal with a lot of issues, including being attacked by her own son. You'll hear a little bit about the defendant being arrested at a certain point for domestic violence battery. He was a juvenile, as he still is a juvenile. And you'll hear that he was put on some probation. But in essence, he was not happy with his mom. So he took her down to the ground and stomped on her hand. But they continued to live together. The mom, you'll hear, was afraid of the defendant and what ultimately might happen to her. And she was afraid he would kill her. But she loved him. And you're going to hear that she wanted to be with him. And she was cognizant of the fact that when he turned 18, he was probably going to leave the house. And that would, for all intents and purposes, end that one-on-one time. And he would continue on with his life however he saw fit. So it wasn't like every day was chaos or bedlam in the house. But the defendant had issues. The mom had some issues. But they were working through them. Now, sometimes they would go to the movies together. Sometimes there would be good days. And you're going to actually get to see kind of like an inside peek of some time on September 7th and September 8th, the day that the defendant killed his mom. You're going to see that in the form of Ring camera footage that Kathy had set up inside because she was so afraid of what her son might do to her. And you're going to see that there was cameras set up in different parts that basically captured the same or similar things. But you're going to get to see some footage from a kitchen camera that captures the kitchen as well as into the living room. So you're not going to have to sit through 48 hours or 72 hours of just nothing happening. But you're going to see some clips so you can kind of tell what the vibe was on those last 2 days of Kathy's life. You're also going to get to be able to see the timeline as it continues. We talked a little bit about